Welcome everybody. It's July 21st, 2020, and we are here for Mediation, the New Possibilities Hour. Today our topic is insurance coverage and COVID-19 update. We're here to raise money for food banks. There's no charge for these programs. Rather, we ask you to contribute to a food bank of your choice if you like what you see. And Natalie, this program began in May. You're the overall organizer. You've done an incredible job. We've raised almost $40,000 so far for food banks. Is that right?
So we actually now have surpassed the $40,000 mark. Jeff, we're at $40,300. And for a little teeny tiny project that was meant to just be, a handful of programs during the month of May, it has really grown into itself. And we're really, really proud of the efforts that our industry have gone to provide support for people with food insecurity.
That's fantastic. And thanks to all of you watching today and all of you who have been watching these webinars since May for your generous support of food banks combating the serious problem of food insecurity. Now on to our panel. We have wonderful speakers for you today. First, alphabetically, is Mike Bidart. Mike is the managing partner of Chernoff, Bidart, Echeverria in Claremont, California. They are lawyers for insurance policyholders. And since March, he has been very busy counseling and representing policyholders in COVID claims. Joyce Wang is a founding partner of Carlson, Calladine, and Peterson, LLP, in San Francisco, California. Since March, Joyce has been very busy counseling and representing commercial property insurers in their responses to COVID claims. And who put together this panel? Who got us these great speakers and organized this wonderful program? Well, that would be Mr. Arnold Levinson in San Francisco, California. For more than 3 decades, Arnie Levinson has worked tirelessly as a plaintiff's trial attorney to achieve robust resolutions for his more than 1,000 clients. And now Arnie is a mediator with ADR Services based in San Francisco, and through the magic of Zoom, serving clients nationwide. Arnie, with that, if you would begin, would like to start by asking each of the 3 of you to mention a food bank that might be particularly important to you. And then Arnie, please take it away with the substantive discussion.
Thanks, Mike. Thanks, Jeff. I donated to the San Francisco Marin Food Bank. Mike and Joyce, got any favorites?
Well, down in Los Angeles, the Los Angeles Regional Food Bank would be my choice.
And San Francisco Marin for us as well. We did a fundraising campaign earlier during the pandemic in our firm for that food bank, and that's the food bank that we're supporting.
Beautiful.
Right.
Thank you.
So just a little note, Joyce is replacing Alex Patente, who had a last-minute conflict and just couldn't be here, but we're really, really lucky to have her. Those of you out there, I'm sure, know Mike Bidart is one of the giants in the field, and Joyce is one of the incredible defense lawyers up here in San Francisco, or from Carlson, Calladine, and Peterson. I've unfortunately had the task of going up against in my past days, and they're amazing. Here's what we'd like to do today. We'd like to go through the major issues in these COVID cases, and we'll get both sides to present how they see the issues. We'll go through primarily the major coverage provisions at first, and then we'll talk about what the attorneys are seeing around the country and in their cases. And then at the end, we will talk about some of the other issues, answer some questions, deal with some of the way these cases are being handled. We sent out an email earlier. If you have some questions, you can send them in on the chat. We'll see if we can get to them during the hour. I'm going to be the potted plant in the middle, basically asking questions of Mike and and Joyce. And so I think we're about ready to get started. First of all, for Mike, what is the primary coverage provision and what's required to satisfy it? I assume we're talking business interruption here. And what is it and how do you come within that coverage is my first question. Oh, and by the way, we're going to be talking about commercial property policies here, all risk policies. I know there's special risk or specified risk policies out there. We probably are not going to get to those in this hour, so we're going to be assuming we're talking about an all risk policy. Mike?
Well, first of all, thank you very much, all of you. You've hit the nail on the head as far as the first obstacle that any policyholder is going to confront is demonstrating that the claim they are making constitutes physical loss or damage to the insured property. Sometimes it's worded in the policies as physical loss of or damage to insured property. I've not yet seen any policy that defines the term. And so in order to make a claim, you need to look to the case law. And that's going to be the fundamental challenge running through all of these cases. Based upon what I've seen thus far in the denial letters that we've seen on the cases we're handling, as well as the cases I've read about going on all over the country, in my view, the policyholders in many cases are taking a dangerous approach when they focus on the nature of the coronavirus as being something that has physical implications on property, etc. The reason I say that is because the cause of the loss, in other words, in any jurisdiction, notably in California, for example, we've seen that the carriers are looking no further than to the policy to see if there's a so-called virus exclusion. And if there's a virus exclusion, they say your loss is coronavirus, you're denied, that's the end of the story. We think, of course, that that is wrong because you have to look to, even if there's an exclusion in an all-risk policy, you have to look to determine whether or not an efficient proximate cause of the loss is a non-excluded peril in an all-risk policy. And so the cases around the country, there are certainly cases on both sides of that issue. But in California, going back to 1962, with the Hughes versus Potomac case, and then thereafter other cases around the country, there are cases that have held that the loss of accessibility to the insured property satisfies the requirement without having physical alteration of the property. But that's going to be a key battle. And the insurance companies are going to take the position that unless there's a alteration of the physical characteristics of the insured property, there's no coverage.
And Joyce, what's the insurance industry thinking in that regard?
Well, Mike hit the nail on the head in terms of framing the issue. Certainly, whether or not the coronavirus constitutes physical loss or damage is going to be a very big issue. I back it up even one step earlier than that and ask whether the insured is able to prove that it's even present on their property. We're kind of assuming that it's present on property, but I'm not so sure that's a safe assumption. So there is some question in my mind as to what's going to be required in terms of proving that the virus is present on property. Maybe if you show that someone was shedding the virus when they were on the property, could get you there, but I don't think it's an automatic. But even assuming you get to the question of whether it's physical loss or damage, and again, those are two different things, that's going to be an area of a lot of dispute. There's quite a robust body of case law on what constitutes physical damage and physical loss. I think my view is that there's a pretty strong majority that requires some physical alteration of property. And while the coronavirus does have physical attributes because it is a virus and it does survive on surfaces for some period of time, The common belief now is that it can simply be wiped away with soap and water, or you can wash your hands of it, wipe surfaces with disinfectant, and take care of it. And even if you don't do that, it's now widely accepted that the virus will dissipate in a matter of time, depending upon the surface. It could be hours, it could be a day or 2 days, maybe up to 3 days, but that it will go away. And so it's different from a lot of the cases that have already been decided as to whether or not it'll constitute physical damage. And the argument insurers are going to make is that it's not physical damage because it can be cleaned so easily, it dissipates on its own, it doesn't damage property in and of itself, and that it's not physical damage. It's early days still, even though it's been a few months. There are a couple of decisions and around the country, not appellate decisions, obviously, but trial court decisions. There was one out of Michigan last month in which the insurer filed a motion to dismiss because there was no physical damage, and the court granted that motion. That was the Gavrielides versus Michigan insurance case. There was another case in New York, the Sentinel versus, or Social Life magazine, I think, versus Sentinel, Southern District of New York. It's a little different procedural posture. The policyholder filed a motion for preliminary injunction, and it was denied. And the court, in the oral argument, made it clear she did not believe that the coronavirus could cause physical damage. So it remains to be seen what courts around the country are going to do with it, and certainly appellate courts, but there are some early indications that are, not favorable for finding physical damage. I have seen a couple cases that are moving toward the theory Mike mentioned, that loss of access to your property is really a physical loss, and there are cases that talk about that as well. But those cases involve where the property has become unsafe to actually even enter the property, or unusable. And with coronavirus, for example, my office is closed, but I can go there, and there who entered the building who tested positive, an announcement was made, the building was cleaned, I waited a couple days, and then it was safe to enter again. So it's distinguishable from the cases that have come down on physical loss. I'm not saying it's not physical loss, but it's a little bit of a jump to get to that physical loss theory. So it remains to be seen.
So there's another provision that I want to talk about, and then I want to get into the virus exclusion itself. And when we get to that, Mike, I'm going to ask you whether it would make a difference if you had a virus exclusion or not, as to how you're going to approach your policy coverage. So, but first, let's talk about the other exclusion, other coverage provision, which is a civil authority provision. Is that a separate coverage? Is it worthwhile pursuing that, or are we back to the basic, property loss provision?
I think with your permission, Arnie, this is, first of all, I have tremendous regard for Joyce and her firm, and over the years we've had cases, and they are exceptional at what they do. And this is really helpful for anybody listening in, because you're hearing exactly what the insurance industry, the position is going to be. But I think it would be helpful, before I address that, if you don't mind,
yes,
to cover what Joyce just covered. Any plaintiff lawyer or any policyholder lawyer trying to capture coverage, I think, is wasting their time if they are focusing on the physical aspects of the coronavirus. The point I'm trying to make in a case where you have 2 or more concurrent causes of loss, you have to look to whether or not the efficient proximate cause is a non-excluded peril. In these policies, there is an exclusion for government orders. And using the example Joyce just gave, if you own a restaurant, and assume for the purpose of discussion that you cannot prove that there was the virus present. Or if there was the virus present, that you came in and you cleaned it all up and you disinfected it, and following Joyce's argument, then you're able to use it because you disinfected it. That's not the point. If you own a restaurant in Los Angeles after March 17, you could disinfect your restaurant all you want, and you could clean it all you want, and it may be perfectly safe to sit in it. The problem is the government said you can't use it. And so there's a government order. So then you have to ask yourself, under California law, is a government order a peril in an open peril or all risk policy? And the answer is yes. The reason I know that is because when you look at these coverages, you'll find in the exclusion sections a section entitled government order. And the government order is a limited exclusion for seizure or destruction of property. And if you apply the rules of construction under California law, we all know that exclusions are to be read narrowly and grants of coverage are to be read, interpreted broadly. And so if you follow that rule of construction, you will limit the exclusion only to the seizure of property or the destruction of property, neither of which the order, for example, in the mayor's order or the governor's order saying either stay at home or specifically you can't have in-restaurant dining. I happened to be at a mediation in San Francisco yesterday and today, and I tried to find a restaurant last night. It's very difficult to find a restaurant because you can't order food inside and eat inside. That is the efficient proximate cause of the loss. That government order, notwithstanding the fact that there's a pandemic out there that caused the government to issue the order. The civil authority coverage doesn't even relate to the insured property. That's when there's an order relating to the property off the premises, causing you not to be able to use your premises. And it's very limited. In fact, what we've already experienced is some carriers are trying to pigeonhole the claim into civil authority coverage when we have to straighten them out and say, no, it's predominant cause of the government order. Sorry for the long-winded explanation.
No, it's fine. It's fine. So as I understand what you're saying, Mike, is that the fact that there's an exclusion in the policy for governmental orders indicates that a governmental order is a cause of a loss.
Right.
If it's an all-risk policy, then it's covered except as excluded. And
right.
What you're saying is it's not excluded in this instance, therefore there's coverage. Is that what you're saying?
That's right. Because in other words, using Joyce's example, but for the government order, the day before the government order, we have a go unnamed right now, a very busy, famous, iconic restaurant that was busiest day of the year, the day before the order hit. And there was already a pandemic. There were people dying in Seattle, there were people dying other places, but they were very busy in Los Angeles, California. But the next day they couldn't operate.
Okay. Joyce, what do you think about that?
Well, I guess I would still be hung up on the requirement of physical loss or damage in the first instance, because the exclusion comes into play if the loss falls under the coverage grant of being direct physical loss or damage. So I still would go back to the arguments that I laid out a moment ago, that there's no physical loss or damage, and the exclusion is really almost irrelevant, because you don't get there. If there's a government order, which of course in many instances there is, that has shut down a location or limited access to a location, I still would go back to, and it's limited to seizure or destruction of property, so you don't have seizure or destruction of property. Arguably, I think there's some argument that there's partial seizure, I guess, but you still need physical loss or damage. So I think it's a little bit circular, but the courts are going to have to kind of sort all that out. So, and I haven't seen a decision that has addressed that argument head on. I think you're still going to need to prove physical loss or damage. I have seen, you know, some policyholders make the argument that the civil authority coverage is implicated. Mike suggests it's limited, and I agree, because of course most policies, and you know, the number one rule when you're looking at, you know, a coverage analysis is to read the policy, because the civil authority provisions vary quite a bit. Most of them require that the order of civil authority be issued as a result of physical loss or damage. So you're right back where you started with not having physical loss or damage. Some of the orders that I've seen, governor's orders and orders, say that they're issued because of physical damage. But there's law that says just because the order says it's because of physical damage doesn't mean that it's so. And there were a number of cases that came down after 9/11 that found that. So, you know, I think the common belief is that most of the orders really are directed at slowing and preventing the spread among humans and limiting human contact, as opposed to being because of damage or preventing further damage to property. So those are my thoughts, and of course you also have an exclusion to contend with in many policies, but I think we're going to get to that separately.
Yeah, I was just about to mention that. And by the way, we haven't really, we've kind of jumped into this, you know, without doing explaining a couple things, but we're talking about essentially business losses for these businesses. They're not open. They can't earn money, and I think that's generally what we're talking about. Plus extra expense, that is ongoing expenses that they can't stop while they're not in business, is what we're talking about, as opposed to, you know, a fire, or loss of damage to the property, or property burning down, or something like that. We're talking about, that's why it's called business interruption coverage. So let's talk about the virus exclusion. There some policies don't have the virus exclusion, although the virus exclusion, I think, is in most policies back since 2005 or 2006. And Mike, I know we've sort of been talking about how to deal with the virus exclusion without mentioning it, but let me send the ball back to you. And how do you deal with the virus exclusion itself?
Thank you, Arnie. And actually, it really segues nicely from what Joyce was just talking about. Pardon me for my laugh. And that is, it's important in order to answer that question. There is authority. In fact, the very first case in the country I know of goes all the way back to 1962 in California, Hughes versus Potomac. Hughes versus Potomac was a homeowner who had a home that had suffered no physical damage whatsoever, but had been red tagged by the authorities because the land beneath the home was not stable and was unsafe. Thereby, the order red tagging it, just like the governor's or the mayor's order saying you can't have in restaurant dining, prevented the policyholder from using their property, and they sued. And the position taken by the carrier was, well, there's no physical loss or damage because we don't insure the land, we only insure the dwelling, and there's no structural damage. Then and that case was then followed by the Western Presbyterian Church case in Colorado in 1968, citing to Hughes versus Potomac. And interestingly, recently, a case decided in the Central District by Judge Bidart, Andre Bidart, in 2018, the intermodal case, was a case where the property that was insured was erroneously delivered in China instead of stateside, and the policyholder made a claim saying, I lost the use of my property. And in that case, the language was loss of or damage to. And an extensive discussion took place on the distinction between the notion of a loss or a loss of versus damage. In other words, since it's undefined, our position is, and the position we'll take, is that the notion of loss is something broader than the notion of damage, which may require physical alteration. But applying the rules of construction, it has to mean something, and you have to give meaning to it. The virus exclusion on this argument, really, it's irrelevant. And that's why I think a policyholder is really on dangerous ground when the overwhelming majority of these policies contain some form of virus exclusion. Most of them have the standard ISO form, which was came into being in 2006 after the SARS epidemic, which says we do not cover physical loss or damage caused by virus, all lists of things. Let's focus on that. Think about the insurance industry's argument when they themselves put an exclusion in their policies that says we do not pay for physical loss or damage caused by virus. Yet, in the same denial letter, they take the position that coronavirus does not constitute physical loss or damage. So that, to me, it proves that they know that it does cause physical loss or damage. They put it in the exclusion. That's point number one. Point number two is applying the rules of construction and the rules that apply to exclusions in California. It's not the policyholder that needs to prove the existence of the virus at the location, particularly when you're arguing that the efficient proximate cause is the government order, but it's the carrier that needs to prove the presence of it so that the exclusion applies in the first instance. In other words, if, for example, you had a policy that didn't have a government order exclusion, which was limited to seizure or destruction, then that government order, it's more difficult to prove that it is a peril that causes a loss, because when they have it in there as a peril, obviously it's provable. I would still argue that in an all-risk policy, anything imaginable that could produce a loss is covered unless it's excluded. So this whole virus exclusion thing, they're, number one, making it appear that just because there's exclusion, that there's no coverage, when the very exclusion itself, in its language, is an admission that virus causes physical loss or damage.
Joyce, what do you think about that?
Well, I guess going back to the earlier comments that Mike just made about the Hughes case and the Western Fire case, as I mentioned, there are 15 or 20 cases around the country that talk about whether smoke is physical loss or damage, or the fear of mad cow disease is physical loss or damage, or ammonia contamination is physical loss or damage. And the cases go both ways. I think more of them find that something has to physically alter the property to constitute physical loss or damage. So I feel that that's a majority view, but there are certainly cases, Hughes and Western Fire being among them, that find more obtuse impairment of property constitutes physical loss or damage. So, that's a fight that remains to be seen, and there is no case that deals with a virus like the coronavirus that can be cleaned with soap and water. So that's going to be a battleground, no doubt. And I think probably all the cases can be distinguished in some fashion from coronavirus. In any event, moving on to the exclusion, and Mike raises the point, isn't it, I guess, circular or illusory to say that we're going to exclude physical loss or damage caused by virus, and then also say that the virus can't cause physical loss or damage. And I think in a vacuum that does sound circular, but the exclusion is designed for all viruses. And just because the coronavirus doesn't create physical loss or damage doesn't mean that there can't be an instance where a virus causes physical loss or damage. I'm not an epidemiologist, but I'm sure there are viruses, maybe smallpox. I feel like the Black Plague, you couldn't go in people's houses, or I don't really know, but there probably are some viruses out there that do cause physical loss or damage. So I would say that in all likelihood, it's not illusory for that reason. Certainly, there are bacteria and that cause physical loss or damage. For example, Legionella, it comes to mind as a possible candidate in that arena. I do think that the virus exclusion is going to be problematic for policyholders because, in most states, coverage is interpreted like other contracts according to the plain and ordinary meaning of the words in the contract, and coronavirus is a virus. So you're kind of starting, I think, at a little bit of a disadvantage on that. I also think that for carriers that don't use the word virus, that's going to be a problem because the virus exclusion has become so commonplace that I think courts are going to wonder why you didn't put it in there if you meant to exclude it. So trying to fit it into a pollution exclusion or, mold or fungi or, bacteria. A virus is not the same as a bacteria. A virus is actually not alive. It cannot replicate without a host, whereas bacteria can. So there's a big difference there. So I think if you don't have the word virus, it's a little harder for the insurer. I haven't had to fight that battle yet, so we'll see how that goes as well. But that's my personal view.
So Joyce, under Mike's analysis, the fact that there is a virus exclusion in the policy, what he's arguing is support for the fact that virus can cause damage to property. Could the carriers who don't have a virus exclusion argue that that's not in there because it's not a peril? So that if they put that in there, it'd be duplicative because virus is not a peril. Joyce or Mike, what do you think?
You could argue that. I'm not wowed by that argument.
Okay.
I mean, it's against my client industry, but I think that's going to be tough because so many policies do contain the exclusion. But just one.
Well, then let me ask you this, Mike. Mike, did you want to say something about that?
No, I was just going to thank Joyce for calling me obtuse.
So Mike,
I wasn't calling you obtuse.
I'm just kidding. I take it as a compliment.
So as I understand what you're saying, you started off talking about a concurrent cause analysis, and you're saying that the efficient proximate cause is the government order. Is that what you're saying?
Yeah, that's an example of an argument where you apply California law when there's concurrent cause. In other words, just to dig a little deeper on that, yeah. I think that it's appropriate to recognize that were it not for the coronavirus pandemic, the government orders would not have come into play. And so certainly without them, there wouldn't be a government order. So the virus, the coronavirus, which as Joyce said, coronavirus is a virus. I agree with that. And because coronavirus is a virus, applying the rules of construction in California, that exclusion and the word virus, regardless if there's other forms of virus, one reasonable interpretation of that is that it refers to coronavirus. Even if there's other reasonable interpretations, applying an objective standard to the interpretation which the law requires, it would conclude that the word virus refers to a coronavirus. But the point is that as long as there's another cause or more than one other cause, you must do an analysis. And a proper investigation by an insurance company would take into account what form of other perils may be the efficient proximate cause. That's what Garvey versus State Farm following Sabella requires. And they don't do it. We're seeing that carriers are simply saying, as I'm kind of hearing right now, hey, there's a virus exclusion, your history. See you later, there's no coverage. And they're relying on that. And we see it. We've seen the denial letters where they're relying without doing any investigation at all. Or after doing an investigation where they ask questions like, do you have evidence that there was coronavirus at a particular location that you own? We're doing, for example, a case for a fitness company's got over 700 locations, and they're asking for each location if there's any evidence that the virus was present. Well, of course, no. And that's the whole point. It's not our job to prove that the virus was present. And if we did, in a case where there's a virus exclusion, we'd be knocking ourselves out of coverage in any event. All we know is that the government orders prevent, just like in the restaurant case, they prevent people from going in and using the facility. But again, I do agree with Joyce that there are cases on both sides of it. And ultimately in California, we think that the current constitution of the California Supreme Court, at least, is that these are very, very thoughtful people who appear to have consumers on their mind, and I think that it's something that ultimately is going to have to be answered by the California Supreme Court.
So, two questions, Mike, about that. Is it a viable defense from the carrier to say, well, you're saying the efficient proximate cause of the loss is the government order, but that's caused by the virus, so actually is the efficient proximate cause is the virus? Could they make that argument?
But the point is this: the reason I don't think that argument works is because what I said earlier is that even with the virus present, even with the pandemic present all over the place, these businesses were open and operating, and they were there, and they were busy. It wasn't until the government shut it down. I mean, it's really clear just what the difference in business from one day to the other as a result of it.
But if they argue that, well, the government shut it down because of the virus, that's the reason they shut it down. Would that be a viable?
Yeah.
And then my next question would be, and I'm going to let Joyce answer this too: is this an issue of fact or law that's going to have to be resolved at some point?
Well, it's for sure a question of fact. The efficient proximate cause is a question of fact.
Okay. Joyce, did you want to comment on that?
Yeah, I guess I still would say, even if the government order hypothetically is the efficient proximate cause of a restaurant's loss, for example, what's the physical loss or damage? Just the loss of use of the restaurant. So then you're arguing that the efficient proximate cause is the government order and not the virus. And then you're arguing that it created physical loss of use of the premises. And the law is, undeveloped, I'd say, on the loss of use argument without, the inability to enter your premises. Fire, it was uninhabitable, you couldn't go in there. So there's some arguments there that are going to be made against that. And I just wanted to touch on one other thing that Mike raised, and that's the notion of statistical evidence, which I think we're going to see that battle done over that as well, because a lot of businesses are going to say, just like the fitness center, we had 1,000 people on our premises every day. We had to have had somebody who was shedding the virus there during a particular time. There are probably epidemiologists who would come down on both sides of that as to whether or not that's, valid expert opinion under the current state of, expert law, evidence. I don't know. So that's another battleground that I see is, I think some insurers are going to make the argument that, we had this many people coming through, this is the demographic, maybe even, this age group and this ethnicity and so on and so forth. And therefore, I don't know whether they'd have to say more likely than not or 100% chance. I don't know, but I think that's going to be an area of debate.
So I want to ask one other question, then I just want to get into a general discussion of what the courts are doing around the country, or what kinds of cases we're seeing, and whether the best way to approach these. I mean, do the carriers and the insureds want to try and get some rulings on this? But before I ask that question, we do have a question about loss of use. Does loss of use constitute property damage under the coverage provision? Mike, and then Joyce.
That's what we're just talking about, is that the notion of the word loss or loss of, I believe a proper construction, applying the California rules of construction, is to give it meaning something other than damage. And in precisely the cases I talked about earlier in California, and the beginning of this was in California in 1962, and most recently, the decision, the very well-written decision by Judge Bidart, was exactly that. In that case, for example, the loss of use of the property resulted from it being delivered to China. And while it was in China, they were trying to get it back. And they were incurring storage charges. And so after months of trying to get it back, to avoid the storage charges, finally they said, oh, the heck with it, just destroy the property. So the carrier took the position that that was a lack of fortuity. And the court said two things. Number one, that they were deprived of the use of the property, and that they were reasonable in trying to get it back, and to then argue that to destroy it or order it destroyed to avoid the service charge didn't destroy fortuity. And so that's really the $64,000 question you ask, Arnie, and that is, will the courts be prepared to find that it can be a sufficient loss? It could be loss or damage if you just lose the accessibility to your property or lose the use of your property. That's going to be the fundamental question there.
It might be a $64 billion question instead of $64,000 question.
It could be. And just for all the defense lawyers that are on, there are about a half a dozen cases that I know of that talk about loss of use, meaning loss of access, that still require that there be some physical component to that. So, again, that's going to have to be decided.
Right.
So let me turn to what's going on around the country and what both Mike and Joyce think might be the best approach for each side to try and get through this and get some rulings on this. I just throw it out there for both Mike and Joyce as to a couple of questions. What are you generally seeing in terms of what the courts are doing or what kinds of cases are? And is there a strategy that would make sense? In other words, how would you tee this up for a ruling if you wanted to get a ruling? I mean, do you want to delay this, or do you want to actually get some clarification? And to add a little bit of complexity to that, what about class actions, multi-jurisdiction litigation, that sort of stuff? What do you think about that?
Well, that's a very, there's a lot of targets there to hit, but the first part of it, it's interesting you asked that, Arnie, because just 2 weeks ago, I was talking to a friend of mine who is defending a case I'm involved in, a very, very good lawyer in Southern California. And I suggested exactly that. I said, if you want to talk about something that will save millions and millions of dollars in terms of legal resources and efficiencies with the courts, etc., we all know that regardless of outcome at the various trial court level and regardless of the inconsistent rulings, that these are going to be working their way up through the courts of appeal and finally to the Supreme Court. It's too big an issue to ignore. Ultimately, I believe that it's going to end up there. So why not fast track it to get it up there sooner? Because I think that, and I suggested to that lawyer, get together with the top law firms that are doing these schemes on the defense side, people like Joyce and her firm, and get a team together. And I would be happy to be part of doing the same on the other side and frame these issues. We've been talking a lot so far this morning about just this one huge issue, physical loss or damage. That could be teed up and framed as a legal issue. And notwithstanding the fact that in individual efficient proximate cause analysis in a given case would still have to be done, but you could still answer the question is, could a government order, for example, shutting down a business constitute physical loss or damage as a legal issue? And you could probably identify a few others that would really help get these questions answered. But again, it's going to be a novel approach, and we even looked at some of the law on that. It's kind of esoteric, and very, very few examples of being able to get straight up to the Supreme Court. But I think with cooperation, it could be done.
Yeah, so I know there's been some efforts at multi-district litigation, particularly back east, but generally the plaintiffs generally opposing that because they want to decide each individual case. But you're kind of suggesting that it might be better off if the plaintiffs could get together somehow and create a way to join forces to get some definitive rulings.
And avoid, because some of the things I've seen, without naming cases or people, whatever, some of the positions being taken by policyholders in some of this litigation, I think are not the right way to go. And I'm sure Joyce sees that on her side too. Positions taken by certain, defense firms or certain carriers maybe aren't the best. But again, everybody wants to control their own case. They think they have a better mousetrap. But it's going to be difficult. I have been told by people that do class action work that they're going to try to MDL these cases as well. And I've read about the efforts back east. I'm not part of that, and I'm not going to be doing class action work on that.
There is some effort.
What do you think?
Yeah, there is some effort in, particularly in Pennsylvania. I know there's at least maybe two cases that they're trying to get teed up for MDL. I know there's one that's supposed to be considered at the end of this month. Another one early on, a court declined. So, there's some effort. The problem, of course, is that every policy, not every policy is different, but there are a lot of different policies out there and variation in terms. I don't disagree with Mike that some very basic, for example, whether it's physical loss or damage, kind of issues could be teed up. I just don't know how to do that. And I haven't seen or been approached about any effort to do that. I've seen some individual cases, and parties are considering whether to file motions to dismiss or deciding whether it might be too soon. Some cases present the issue of whether there's the presence of the virus, and that needs to be kind of sorted out. So right now, I'm not seeing a clear course toward an organized advisory ruling, although one may develop later in the year, but I haven't seen that.
I'm just wondering, is it possible or even feasible? It's probably not feasible, but maybe it's possible for a group of plaintiff and defense attorneys to get together and maybe stipulate to consolidating the cases and to a basic set of facts and submitting it to a court on summary adjudication or summary judgment or something like that, either in federal or state court, to try and at least get some rulings out there, so the parties can see what the courts are doing. It seems like it's going to be years, and I'm kind of addressing this to Mike, because you got to go through the trial court and then the appellate court, depending on whether you're in federal court or state court. I know there was a court in Pennsylvania that kicked it back to the Pennsylvania Supreme Court, saying that actually they remanded the case back to the state court because they said it's an issue of law for state of Pennsylvania that they're unfamiliar with. I'm just
Right.
wondering, is it even possible to do that, or practical?
I think a stipulation of facts is not workable because they'd be all over the place. But I do believe that certain rulings could be tied to certain issues. For example, in all of these policies that I've looked at, I've never seen anything other than two phrases: physical loss or damage, or physical loss of or damage to. And then, and it's never defined. And so you're going to have to do, as Joyce was arguing, go to the case law and make that argument, and make the argument with respect to this coronavirus pandemic. Of course, I think it's clear from the discussion today that I believe that it's in the best interest of policyholders to de-emphasize the presence of coronavirus at a particular location, because I don't think that's the issue. And if it is there, you're running yourself into the ditch on the exclusion. So it's not in your client's best interest. And I don't believe it's true. I believe that the real predominant cause was the government order. I truly believe that. Again, some court may disagree. In other words, but as a fundamental legal issue, I think you could frame it not a factual statement, but a legal issue as to whether or not a peril such as a government order that says the following, you have the language, could constitute physical loss or damage. If the trier of fact determines that it's the efficient proximate cause.
Jess, did you want to respond? I've got a couple of questions.
Yeah, I mean, I agree that would be great, but I don't know how to do that. And I don't know, for example, if I could even represent more than one carrier in an effort like that. It seems like that could be ethically challenging. So I don't know how to get to that place. But I do think that there will be some rulings on physical loss or damage, or physical loss of or damage to, in the near future. Because I do think cases are going to start to get teed up, and motions to dismiss and then summary adjudication are going to be filed, and we're going to start to see some decisions. And that may kind of help create some momentum, one way or the other as well.
Well, that was going to be my next question. What are you seeing around the country in terms of cases teed up, the types of cases? I mean, there are thousands and thousands and thousands of cases being filed all the time now. What are you seeing around the country in terms of what the courts are doing, or where can we look, if you know, as to where we might see a decision coming from at some point?
Well, I mentioned the two cases earlier, the Gavrielides case in Michigan, which was on a motion to dismiss by the insurer, which was granted, and then the Sentinel case in New York, which was the policyholder's motion for preliminary injunction. I know another case in the Southern District of New York where the policyholder wants to file some kind of a preliminary motion. It might be for judgment on the pleadings, if I recall, and to tee it up before discovery. So I'm seeing some of that going on, that's about all I've seen so far.
I have a state court case for a restaurant in Los Angeles that we got a demurrer from that same firm I mentioned. I suggested this approach, and the demurrer takes this issue on, having to do with physical loss or damage. So that's going to be heard November 9, and so that'll be my first ruling on it. We have other cases already filed but haven't had any law in motion yet.
By the way, if anybody has any source where they can, someone could go to see what cases are filed around the country, they're free to list it on the chat here. I only know of one source so far. I know United Policyholders website does have somebody trying to keep track of these cases. You might check that. I don't know any other source, either on the defense side or anybody else. But if anybody in the audience knows of a good source, feel free to post it here. We're almost out of time, but I have got one last question I wanted to throw out there. It's kind of an unusual question, but the question really is, can the insurance industry, including, reinsurers or whatever, can they afford to lose? Can they pay all these claims? Either one of you, go ahead.
Well, I only know what I read, and of course, I don't know about the financial condition of all these carriers. I know that they've said they can't, and but I don't have actual firsthand knowledge if that's true or not. I do suspect that it would be a huge, huge financial hit, no question about that. And it may be ultimately, and I thought from the beginning that since there's so much other activity going on in the form of government assistance and bailouts, for lack of a better term, that perhaps some government assistance backing up this issue with the industry, et cetera, might be possible. But that's really way out of my league, Arnie. I don't know.
Yeah.
Yeah, I don't have any intelligence on that, other than I agree with Mike. It would be obviously a huge hit. I mean, just think about his one client with 700 locations of gyms. If all of their business interruption losses for the last 6 months were covered by insurance, and you multiply that times the millions of insureds, it's a phenomenal amount. And I think back to what has happened in other catastrophes. You have to be careful what you wish for, because the impact on the insurance industry could be adverse as well. So
but it would be good. It would be great for the Los Angeles Regional Food Bank if I won that case.
And what a wonderful note on which to end. Mike, thank you so much. Mike Bidart and Joyce Wang, you're wonderful professionals. You answered a lot of questions and you raised a lot of questions. So in all those regards, it was a wonderful conversation between you. And Arnie Levinson, thank you so much for organizing and moderating such a wonderful discussion. 3 cheers for you, Arnie. Thank you very much. Mike, Arnie, Joyce, just a tremendous conversation. Please support the food banks, the LA Regional Food Bank, the San Francisco Marin Food Bank, or whatever food bank is near and dear to your heart and close to you geographically. Thank you all very much. Natalie, any last words?
I just wanted to say thank you so much. This has been a fascinating interaction. What an excellent sort of backstage view into the thought processes of what we're all about to face.
All right, with that we are complete. Thank you all very much.
Thank you. Bye.